Hallo Snus-Freunde, wir sind hier live in Luxemburg nach der Anhörung vor dem Europäischen Gerichtshof und wir haben hier, zwei Gäste. Heute wird das Video in Englisch erscheinen, muss man dazu sagen. Ich habe hier Bengt Wiberg von Snus und Gerry Stimson von Nicotine Alliance und der Bengt wird jetzt ein Interview mit dem Gerry führen. So der Eindruck nach der Anhörung.
Hallo Deutschland, Österreich und Switzerland. Here we have the well-known Professor Gerry Stimson, and we would like to ask him how the trial went today, the first trial, historical trial.
Historical trial, it certainly is a historical moment. It's been a long process, and today is only one step in that process. We're here at the Court of Justice in Luxembourg. In fact, we're not in the Court of Justice, we're in the bike shed because we're not allowed to film inside the Court of Justice. But it's been an interesting day. It's a strange process because you have all the lawyers who are presenting the case against the ban on snus, and you have lawyers for those who are arguing against us. So everybody gets 15 minutes to give a brief summary of the main points of their case, but of course there's also huge documentation on the case which has already gone into the court and which the court examine later. It's a kind of a mixed feeling coming out. It's a bit like coming out after an examination and you're not quite sure how you've done, and it's going to be a long time before you do know the result. On the negative side, we've had the repetition of the arguments that we've seen from the European institutions about snus. I mean, really a distortion of all the facts that we know about snus, a distortion of what we know about the effects of snus, an emphasis again and again on harmful effects and addictiveness. And addictiveness is never really explained, but it's seen as a problem in itself. Plus an argument that there's no new science, and even if there is, such are the disputes amongst the scientists that in a sense the legislators have to make their own decision about one way or the other. Now that came out from the Parliament, from the UK, from the Commission, Norway, UK, and it really becomes very repetitive. I mean, other elements of what they're saying is that, dangers to children. If you allow it, then children will start to use it, they'll become addicts, they'll become smokers. So this is all stuff that we've heard before with respect to snus, and we've heard it with respect to e-cigarettes. It's what I call the FUD, the fear, uncertainty and doubt approach, the FUD approach to policy making. So you express concerns, not enough is known, hence the solution is to ban. And that's part of a legal argument about a proportionate response. So those against us are saying it's proportionate to have a ban because there's no other way you can actually control this beast that is snus. And if you let loose the beast of snus on Europe, then there will be all sorts of terrible consequences which will follow. So that's the negative side. On the plus side, the judges had clearly read a lot of the documents, and there were 6 judges in the court, and they asked some very pointed questions, both of our side, and our side is represented both by the New Nicotine Alliance and Swedish Match, but in particular they were asking some very pointed questions of the European institutions about their use of science and how they decided between one bit of science and another that one bit might be more worthwhile than another. And one of the judges at the end said something like, well, it seems that you get a lot of facts and evidence and you put it in a blender and it comes out with the position that you want to present. So use that word, you put it in a blender.
Put it in a blender. That's what we do with snus.
And another judge said something to the effect that, is it the case that because the ban has been in place so long, it's politically very difficult to lift the ban? So in a sense, the EU institutions become impervious to other comments, to criticisms and other evidence. So it looks, there's a little bit of a hope here. It's a difficult case, but given the judges do seem to have got to grips with some of the key arguments, and almost saying, in a sense, we've kind of heard this a lot from the Commission on different cases, and really, you know, you've got to be a bit sharper in your arguments. So that was good. And also was good, what was good was Paul Diamond, who is our legal representative. Look, he gave a rather different argument about the case, which was about the rights of people in the European Union to have access to a safer nicotine product. He talked about sensible adults making sensible decisions. He talked about the arrogance of the European institutions in wanting to interfere in the decisions that adults could otherwise make. And that actually brought a lot of life to the proceedings, which until that point had been rather dull. But that was our high point at the end, to really say that, you know, everybody is here discussing people out there who are affected by this. You know, people who smoke, people who use snus, people who want to use snus. Decisions in the court actually affect a lot of people outside who don't get a voice in this matter. So that was a nice way of ending it.
Thank you, Gerry. I am personally very optimistic. So you talk so passionate about tobacco harm reduction. So you must be a snus user.
No thanks. I've tried to use snus, but I've failed. I've tried to use e-cigarettes, but I've failed. I'm one of those people who is like a failed nicotine user. I don't, well, I smoked when I was younger. I haven't smoked for about 40 years. But I have great faith that people can make their own good decisions about their health. I think that the obstacles we're putting in the way of people making those decisions are inappropriate. As a public health scientist, I've always believed that you should create the conditions where people can make their own sensible decisions. That you need more carrots and fewer sticks in life. You know, we're trying to beat smokers over the head. We're trying to stigmatise smokers, trying to stigmatise snus users. There were comments in the court today about one of the difficulties with snus is that people can use it surreptitiously. You know, they could use it in places where they can't smoke and kind of get around the law or get around everything we're trying to do to get them to stop smoking. So that, you know, it's Paul Diamond's words, that arrogance in tobacco control and in some aspects of public health is something I've always fought against. So I really think that doing good in public health is helping people to make the decisions that are good for them. So no, I don't use snus.
And there's no such thing as a passive snus user, right?
That's correct.
I'm not disturbing you right now.
No, you're not.
I got two of these little devils up there, right?
There is no passive effect from snus, as to there's no passive effect from e-cigarettes. So these are things which are invented to scare people. So no, you're not, even though you might be doing it secretly, I'm not at all concerned about that. No. Good luck to you.
Thank you very much, Gerry.